Hey, welcome to today's video. I'm Rick Chapo with DMCAAgentService.com. So today we're taking a look at DMCA Safe Harbor highlights. What is the DMCA? It is a federal law in the United States. It was passed by Congress in October 1998 and signed into law by President Clinton on October 28th, 1998. The DMCA stands for Digital Millennium Copyright Act. It is, as the name suggests, a provision that is dealing with copyright issues, typically with electronic devices as well as in the online environment. Now, the DMCA did not come out of the blue. It was actually a reflection of two treaties agreed to with WIPO. What's WIPO? The World Intellectual Property Organization. It's an organization with a number of different members. Most first world countries, for instance, are part of it, including the United States. And in 1996, after much yelling and screaming, some treaties had been agreed to by various countries that set forth sort of a skeleton framework of how certain intellectual property issues would be dealt with moving forward, including copyright. And the idea here was they wanted to create kind of a common theme, if you will, some high points that each country would follow. So there would be some, commonality, some consistency across copyright law as it dealt with the internet, certainly from country to country. Because, of course, the internet doesn't have borders. And so if somebody in the U.S. is communicating with somebody in Germany, well, which copyright applies, and if the copyright laws are vastly different, it causes all kinds of chaos. So that was kind of the idea. So the DMCA itself, the federal law, it actually addresses a number of different areas, some to do with things like digital rights management, but we're going to focus solely on the DMCA Safe Harbor provision. This is found in Title 17 of the United States Code, Section 512. And I'm not going to read it to you because your heart would literally stop from boredom. It's written in classic legalese. So let me just explain to you. What it says basically is that if you are an internet service provider, you cannot be held liable for copyright infringement claims based on content uploaded by users to your platform or using your service. So what are we talking about here? Well, let's use an example. First of all, what's an internet service provider? Basically, it's anybody online or anybody that's giving you access to the internet. So it could be, let's say you're at home and you're accessing the internet through your cable provider, the cable provider being an internet service provider. If you're on your smartphone and you're using, an evil company like Verizon, Verizon would be an internet service provider, but it would also be websites online, search engines, social media, apps, as long as the apps are internet connected. Basically, anything there. About the only group that's kind of sketchy, classifying as an internet service provider would be peer-to-peer networks, because there's technical questions there that you really don't want to know about, but get into questions about, who's hosting what. So basically, anybody's an internet service provider. So then how does this all work? Well, basically, let's use an example. Let's say you're a J.K. Rowling fan. You love the Harry Potter books and movies. And so you start HarryPotterFanForum.com. And this is a forum where Harry Potter fans can come and post all kinds of different things. So a lot of them will come on and talk about, different Potter issues. Ron Weasley's great. Ron Weasley is horrible. These kinds of things. Now, what are they also going to do? They're going to post pictures and other visual content that they find online. And the tricky thing about that is that visual content is actually copyright protected. So whoever created it is automatically vested with copyright in it. And that means they have the right to distribute that content or to use that content in any way they see fit. And nobody else can use it without their permission, unless certain statutory defenses apply, which for the purpose of our discussion, we're just going to ignore. Otherwise, this becomes like a 6-hour video. So let's say a Harry Potter fan goes out and they copy a photograph of Ron Weasley that a professional photographer took and put up on a site. And they copy that and they post it on your forum. Okay, well, in doing that, they're committing copyright infringement. Can they be held liable for that? And the answer is yes. But what about you, the forum owner? And under the DMCA Safe Harbor provision, the answer is no. Because again, an internet service provider cannot be held liable for copyright infringement claims based on content uploaded by users. And that's exactly what we're talking about here. One of the users of your forum has uploaded a copyrighted work, this photograph, without permission of the copyright owner. They can be held liable. You cannot. It's pretty much that simple. Now, there are all kinds of little technicalities you can get into if you want, but that's the basic idea. Now, why does this safe harbor exist? I mean, isn't this great for websites and apps? And the answer is yes, it is. The reason it exists is, again, remember, this was enacted in 1998. And at that time, the commercial internet was a baby. Most people were on dial-up modems. We weren't even on broadband. Your phone accessing the internet? Ha! You know, we're talking caveman time for the internet. So nobody really knew what was going to happen. And the government was passing a variety of laws, not just the DMCA, that were designed to create an environment where businesses could start, and some of them would fail. Some of them would grow into behemoths, but they wouldn't fail because they were being sued right and left for all kinds of, real world claims. So they created kind of this safe harbor where, these businesses could grow without being crushed by, storms of lawsuits. And that's the basic idea. And that's why it existed. Now, can you waive the DMCA safe harbor provision? Yes, you can. There are a number of different ways to do it. Kind of the common ways that we see is basically a failure to meet the compliance process. So there's a catch. If you're going to take advantage of the safe harbor, you have to meet a certain number of requirements that are dictated in the DMCA. Now, that compliance process is way beyond the scope of this video, but if you go to our site, dmcaagentservice.com, or if you're on our site right now watching this and you look up at the menu, you'll see a link to DMCA compliance. You can go there, click it, and you can read about it. But there are a couple different provisions. One is you have to designate an agent, and you have to register that agent with the Copyright Office. A lot of companies have lost the DMCA safe harbor and been sued for copyright infringement because they did not designate an agent. Obviously, we provide agents, DMCAagentservice.com. That's one area. Another area is maybe you post the questionable content yourself. So remember, the safe harbor only applies where an independent user has posted the content. If you own the site and you go out and find the content in question and you post it on your site, or one of your employees does, or one of your moderators does, then there's no DMCA safe harbor protection, because we're only going to give sites and apps a break if it's a third party, an independent third party who commits the act. If you do it yourself, that's your own fault. So, and there's another area called the repeat infringer policy. So the repeat infringer policy requirement just says simply that if you have a website or an app and somebody is repeatedly accused, one of your users is repeatedly accused of copyright infringement, well, if that happens, X number of times within X period of time, you have to terminate them. You can't let them on your site or your app anymore. And they're just trying to prevent, repeat infringers. I mean, the name's kind of self-evident. Now, a lot of companies fail in that area, small and large. But one big company is what we call the USS Cox case. And that would be a picture of them off there on the right. Cox is a cable provider in Southern California. I don't know where else, but I'm using them right now to record this video. And basically, that's how I access the internet from my desk on my PC. And they had a repeat infringer policy, but they didn't enforce. Well, they did enforce it, but then they did something strange. So if a user of Cox uploaded a bunch of infringing content and they violated the repeat infringer policy, Cox would terminate them, which is exactly what they were supposed to do. But then a month later, roughly, they would send out a notice. Hey, you want to sign up again? They would let people back on the service. Well, the people had started abusing copyright again. And so it was a repeat infringer situation. And the court found that Cox had waived the DMCA safe harbor provisions. And Cox was eventually found liable for a very low $25 million. So we're talking about serious stuff here. So make sure you understand the DMCA safe harbor provision. If you have a website or an app and you're allowing people to upload to it, comply with the DMCA. It's not very expensive, and it will give you immunity from one of the biggest potential threats online to your business. What about future DMCA changes? Well, there's really nothing on the cards in the United States. The DMCA has been around for 21 years now, and there just seems to be no real interest in Washington, D.C. in making any changes. However, the EU has passed a copyright directive this past spring in 2019. It'll go into effect over the next couple of years. It'll be interesting to kind of see what happens there. Basically, what the copyright directive says is that companies with larger amounts of data that are holding larger amounts of user-generated content are going to have to filter that content. They're going to have to find a way to essentially identify and remove infringing content before it gets up on their site. So we're talking Facebook, YouTube, these kinds of sites. Now, YouTube already tries to do this. They have something called a content ID system. If you've ever uploaded videos to YouTube, you know about it. And it's hit and miss at best. Personally, I think it'll be a boondoggle, but hey, let's see what happens in the future. So the DMCA Safe Harbor, if you have a website or an app, you absolutely want to comply with the DMCA Safe Harbor if you allow users to post anything to your website or app, because it's cheap and it gives you immunity from copyright infringement claims based on the content they're uploading. And let's be honest, you have no idea where they're getting that content. So that's it for today's video. Thanks for watching. Have yourself a good one.